Hello, everyone. Welcome to Court with Krissy. I'm back with Disaster Strikes Twice, Part 2. Is it possible for things to get worse? Watch and find out. And if you happen to miss the previous video, the link is in the description. I hope you like it. Court with Krissy is now in session.
All right, thank you everybody for your patience. Two cases, 2024 113 PP, Lindsay McKediak versus John McKediak, and 2024 391 PP, John McKediak versus Lindsay McKediak. In the first case, 113 PP, Attorney Huffman represents the respondent.
Good morning to all of you.
Good morning.
Good morning.
Court notes this matter is a continuation of the hearing commenced on June 10, 2024, in which testimony was taken from both of the parties at that particular time, and that we needed to acquire some of the exhibits that Ms. Huffman was not able to provide at that time. Those have been provided to the court. I will note that we do have the phone records from Verizon on the respondent's account for the month of January and February in this matter, but those were the only ones that I received. Ms. Huffman, were there any other that I was supposed to receive that I didn't receive?
I do believe there should have been an April 20, the last, I'm sorry, hang on one second. April, I'm sorry. March, the one in March, I do have that available to share. I believe that would be the only one the court should be missing. All the rest should be available to the court. And then I did provide a copy of the proof of service to the court. I believe Mr. McKediak had a witness that he wanted to provide for that, but I'm not sure if he has that witness available.
Okay. Well, last week was the time and place set for those particular witnesses.
I have nobody in the waiting room.
There's
right now.
no one in the waiting room, so there's no one to present, even if you wanted to at this time. Ms.
Okay.
Hoffman, why don't you do the share the screen, and we can look at the March, because that is the only one that I'm missing. Okay,
I think this has all of them, so I'll just scroll down to March. Right there's March.
and if you would highlight the March 18th, 2024 date, and if you could enlarge that so I can see it, because I can't see that.
Okay. Yes, I can do that.
So March 18, 2024, or the times, if there is none, then the time's right around that.
Whoops. March 18th is there. Does that highlight that for you?
Highlights, can you enlarge it though, is what I'm looking at.
Yeah,
No, you took it away from me, so I can't see it.
is it gone now?
It's on the screen. Oh, okay, hold on. Put it back to what you had there. I could see it then, but it's on our large screen, but I have another one on my desk that it appeared on, but then it disappeared. Can you highlight that?
Not me, no. That's her.
Can you bring it on my screen here? Maybe I can see if it comes up here. It came
There
up.
we go. Is it? Whoops, sorry.
Okay, hold on. Don't touch it.
Okay.
You had it on my screen, and then whatever you did, it went off my screen.
It should be there for you. I'm
Okay.
seeing it highlighted.
One thing that will help here, Shelley, is for you to X that all tools on the left. That should give us more on the screen. That X that you have on that left. It says all tools, just go over to that X so you can collapse that side.
No,
And
yeah, right there. Okay, great.
there, that should look a little bit better.
I'll ask the petitioner, Ms. McKediac, can you see that list of calls?
No, I cannot see it.
She's via telephone.
Oh,
She
okay.
can't see.
Going down there because I can't see it. McKediac, I've got a number of calls, probably about 10 to 12 calls on March 18. Give me, just give me the first 6 digits of your phone number with the area code, because I don't want you to have to disclose your entire phone number. What is your area code, ma'am?
269
Okay, so, and what are the next 3 digits?
268.
268?
But yes,
Okay,
but I would like to just mention something, if I can.
yep, we'll give you time in just a minute. I was just checking out the list.
That's fine.
Okay. Okay, Ms. Huffman, if you want, you can take that down. I've had a chance to review that.
Your Honor, if I could just add that there, I believe, is a color photograph that we did present to the court that shows a car accident. It could be one in black and white, but it's a photo of across a guardrail, sorry. And then there's a wrecked car on the other side of that.
Okay.
Um,
And what's the purpose of that?
That is my client's vehicle in Florida when it was wrecked in Florida, which is why he got the and there was a person that died in that accident. And my client had to get a rental car when he got back. And the only reason I'm provided that is because the petitioner indicated that the only reason my client would have rented a vehicle during the time in which we showed the court that there was a rental receipt would have been to drive the vehicle to Florida. That proves my client that was his vehicle that was wrecked, and the reason why my client had to rent a vehicle when he returned back to Michigan.
Okay. Okay. And Ms. Huffman, are you offering the again, the picture and the phone records as exhibits in this matter?
I am. So the January, February, and March could be admitted as one exhibit A, or one, however the court wishes. And then the pictures could be admitted as another exhibit.
Okay. We'll do that as exhibit 1 and exhibit 2. Okay. Anything else, Ms. Huffman?
I don't believe so. Thank you.
Ms. McKediak, anything else that you have?
I just like to say that, I called her done, and I via Wi-Fi. All that.
Okay,
And I
ma'am,
want
you're
to know.
coming through, you're all jarbled, so I can't hear very well.
No, I'm sorry. Honey, okay, I'm sorry. The phone call via Wi-Fi, not showing on here.
Okay, first of all, you're jarbled, and we've got a child screaming in the background, so.
Nothing further.
Ma'am, why don't we do this? Why don't you disconnect and then reconnect? Maybe we can hear you better.
What's that?
Ma'am, end the call and then reconnect. And then we should be able, hopefully we can hear you better. No, she did. We had no problem hearing her last week.
That is.
Can you hear me?
Yes, we can hear you, ma'am.
Okay, I'm so sorry about that.
That's all right.
My son, he's autistic and I'm at a school, and so this
Okay,
is the
well,
wrong.
ma'am, first thing I want to ask is, in this matter, Ms. Hoffman has offered Exhibit 1 and Exhibit 2 in this matter. Do you have any response to the offer?
Just that with the phone calls that if he was to call like via Wi-Fi, because
Okay, ma'am, I'm just asking
doesn't
as it
show on a
relates,
phone bill.
ma'am, hold on. As it relates to any legal objection to the offer of those.
That it wouldn't show up on a phone record.
Oh, okay.
That it would not show his phone bill. Wi-Fi phone calls do not show up on a phone record.
Okay. We will address that.
App phone calls also do not show up on a phone record.
Okay. Anything else as it relates to that?
And I mean, other than his situation in Florida, I don't know what his situation in
Okay,
Florida
well, let's address,
was
I want to address, hold on, I want to address the exhibits first. The court will admit, respondents exhibit 1 and 2 in this matter, there being no legitimate objection to those. With that, I guess, Ms. Huffman, you have nothing else, is that correct?
I have no further evidence. That's
Okay.
correct.
Okay, Ms. McKediak, anything else that you have in this matter?
Just that I was contacted and told that he was in Florida. Now his situation.
Objection. I'm
Florida,
going to
I
object
don't
to
know.
that being hearsay.
Well, we've established he was in Florida, so that's, I guess, not a big issue. So go ahead, Ms. McKediak, anything else?
That is just what he had stated to me. I don't know what his situation was. It's during his phone call, he had stated that he was in Florida. So, I
Okay.
mean, that's all I know. I don't know his situation of what took place or when he left or when he got back. I don't know.
Okay,
Wasn't discovered over the phone call.
okay. Ms. McKediak, do you have any closing argument to make?
I mean, no, I guess not.
Okay.
No.
Ms. Huffman, any closing argument?
Yeah, so I would just state that, on February or for the February 11th incident, Ms. McKediak several times stated that he was in Florida. She stated, that it was a FaceTime call, that, she knew that he was in Florida. Just now, she said that someone told her that he was in Florida. When she testified, she said he told her he was in Florida. I just objected to her as her stating that somebody told her that as hearsay. But she said that anyway, the court allowed it. So I'm just saying that's what she just said right now, is that someone told her. And her, if I could just give my argument without interruption.
Yeah, Ms. McKediak, do not interrupt.
Thank you. My client simply wants nothing to do with Miss McKediak. He wants to get his divorce over. If that hasn't ended yet, last I knew, I think it was still open. He just wants to be divorced, be done with her. He wants absolutely nothing to do with her. He's not contacting her. There's no proof that he's contacting her, even though she said for his January 27th call, that it came from his phone. Specifically, it says, I spoke to both of them and it was from his phone. I provided the phone records for January, February, and March. None of these, in fact, not just those days, but every day. And none of the days have any calls to either of her number or her son's number, which she stated he also called her son's number. Those numbers are not on any of his records. The records come directly from his phone company. They don't take numbers out to satisfy what Ms. McKediak wants them to say. So again, I would just, there is significantly insufficient evidence to find violated any PPO. Thank you.
Okay, thank you. Again, anything else, Ms. McKediak, before the court gives you a ruling?
Just no, he'll just keep bothering me.
Okay, thank you.
Bothers me with different people, and so.
Well, if there's other people that are bothering you, you can always get a PPO against them. Again, that doesn't pertain to respondent. As a result, the court is not going to address that. Specifically in the petition to show cause in this matter, the petitioner had alleged various dates on which things she said occurred. The first date was January 27, 2024. Second date, February 7, 2024. Then February 11, 2024, and then March 18, 2024. She also claims that, again, there was a FaceTime call. I think that was the February 11, 2024 date. In this matter, the court has looked at the Exhibit 1 and looked at those particular records. The records show on the January 27th, 2024 date that she claims, and she delineated what the call was, etc. And the court will note that on his phone records, it does not show any calls from his phone to the 269-268 number, which she identifies as her number. Further, in this matter, that is the January 27th date, the February 9, 2024 date in which she delineated a call to her. That looking at the records, there was no call from his phone on that date. On the 2/11/2024, the date of the alleged FaceTime call, that in fact there was no FaceTime call on that. Plus, the testimony of the respondent was that in December 2023, that plaintiff had blocked him from all social media contact to him. Further, on March 18, 2024, which we saw today, there was no call to the plaintiff on that date from his phone call or from his phone number. Taking all of that into consideration in this matter, it does amount to more than a he said, she said, as he has provided documentation and evidence to show that he did not contact her. And as a result, the court will deny the show cause and deny any finding of contempt in this matter. The court will next go to the respondent's motion to terminate. He alleges that he did not do any of the things as alleged. Court will note that credibility is always a consideration in every case, and especially these types of cases. Oftentimes, a party will allege that the other party or one of their witnesses is not truthful or lying. The court has found that inconsistency in testimony does not mean that an individual has lied. Conflicting testimony can occur as a result of a witness's background, perception, bias, understanding or misunderstanding or mistake. And when consistencies occur, the court will attempt to determine if they can be reconciled by other testimony or evidence. In this case, we have diametrically opposed testimony, so the court has to look at other evidence, and that other evidence is the exhibits that were submitted in this matter that shows that the respondent, Mr. Makidiak, has not contacted her in this matter. And so that evidence presented goes to, again, more than simply a he said, she said, but is backed up by other objective evidence to substantiate that, again, there was not contact. I'm not saying that there's not anything that's alleged to have happened in this particular matter, but it does, again, go to the issue of credibility when we have someone making various statements and then that testimony being again refuted by objective evidence in this matter. As a result, based upon that, the court will grant the respondent's motion to terminate the petitioner's PPO in this matter. And I would simply caution both the parties, don't communicate with each other, don't contact each other. And in your case, Mr. Makidiak, even though the court has terminated that, I'll let you know that the court could at some future point grant a new PPO if the circumstances warranted that. You understand that, sir?
Yes, sir.
Okay. Okay, that will be the order of the court, or the orders of the court in this matter. And we'll conclude this case. You're free to go. Have a good day.
Thank you.
Thank you so much.
Thank you. Have a good day.